The specific details of the big stories now, and we're starting from the big one, having to do with the fact that the current Chief Justice, Madam Gertrude Torkonoo, has been removed from post with immediate effect. The decision follows recommendations from a constitutional committee set up under Article 146 of the 1992 Constitution. The move comes after the President received the report of a committee constituted under Article 146(6) to investigate a petition filed by Ghanaian citizen Daniel Ofori. After reviewing testimonies and extensive evidence, the committee concluded that grounds of misbehavior, as stated under Article 146(1), had been established against the Chief Justice. It subsequently recommended her removal from office. In line with Article 146(9), President Mahama has obliged to act on the committee's recommendation. A statement issued by the presidency and signed by the Minister for Government Communications and Presidential Spokesperson Felix Kwakye Ofosu confirmed the dismissal, emphasizing that the decision takes effect with immediate effect. We will speak to some lawyers shortly, but first let's listen to the chairman of the committee, Justice Gabriel Scott Poamang, speaking when he presented the report to President John Mahama earlier today.
Ladies and gentlemen, Mr. President, in March this year, we received 3 petitions pursuant to Article 146 of the Constitution 1992 for the removal of Chief Justice Gertrude Esaaba, Araba, Torkonoo, and the public was made aware of this fact. Subsequent processes dictated by the Constitution and the decisions of our Supreme Court were gone through, culminating in the establishment of our committee under Article 146, Clause 6 of the Constitution. The nation was further duly informed, and when we commenced our work on the 15th of May 2025, the Minister of State for Government Communications was briefed to notify the public about it. There has been considerable interest in our work, shown through comments and opinions by Ghanaians and international observers as well. However, the committee restrained itself all along from reacting, even when blatant false statements were made about members of the committee and our work. To the committee, our mandate and remit is set out under Article 146, Clauses 7 and 8 of the Constitution. It's clear, and it is to inquire into the petitions in camera, hear the person against whom the petitions have been brought in her defense, by herself or by her lawyer or other aspect of her case, and then make a recommendation to you, Mr. President. As I have said above, 3 petitions were referred to us. And though all 3 petitions seek the same relief, each petition is distinct and will succeed or fail on its individual strengths or weaknesses. Mr. President, without disclosing the substance of the proceedings, and since in-camera proceedings is not the same as in secret, we can state that in respect of the first petition, we received evidence by Mr. Daniel Ofori, the first petitioner, through 13 witnesses. Similarly, the Chief Justice in her defense called 12 witnesses, including expert witnesses, as she is entitled to do under the Constitution. The Chief Justice testified personally and was cross-examined. The committee received about 10,000 pages of documentary evidence from both sides. There were 4 lawyers that represented the first petitioner, Daniel Ofori, and 4 lawyers represented the Chief Justice. Mr. President, after critical and dispassionate examination and assessment of all the evidence, including the expert evidence, against the provisions of the Constitution and the relevant laws, we have, without fear or favor, arrived at a recommendation on the first petition. The recommendation is contained in the envelope which I now give to you.
And that is Justice Gabriel Poamang, who is a the chair of the committee set up by the president, the Article 146 committee, to look into the petitions that had been submitted to the president for the removal of the Chief Justice. Now, this committee, after months of investigation and interrogations, have put together their report, which was presented to the president, out of which the president has followed through with recommendations captured in that report, key among it being the removal of the Chief Justice from office. So right now, Madam Gertrude Esaaba Torkonoo is known as former Chief Justice because with immediate effect, she has been removed from her post. In a jiffy, we'll go to the phone lines and get the thoughts of Martin Kpebu, who is a private legal practitioner. He's joined us for a quick conversation on this. Mr. Kpebu, good evening and thank you for joining us on 3FM 92.7.
Good evening, name. Evening.
Yes. To start with, from where you said, what do you make of this particular order from the office of the president? The president says they are following through with the recommendation of the committee that was probing the petitions. And did this come to you as a surprise?
Yes, it came to me as a surprise in terms of the timing that the committee had decided to present the report on the first hearing. You say, the petitions are 3, and the committee decided to hear them one by one. So for a lot of us, we thought they would hear all 3 cases and then present reports on all of them at the same time. But the committee, of course, they are better informed. Sometimes when you are not involved in something, the way you think is different from those who are in the saddle. So for the committee, once they finish this one, and especially as you see, Martin, it said that Chief Justice Torkonoo came and sought an adjournment that they should not hear the other ones now. She sought an adjournment. And if they've already finished one, and the respondent, that Chief Justice Torkonoo, has sought an adjournment, it makes sense to go and present one report, you see. So for me, as an outsider, I was surprised because I thought we were going to deal with all 3, and then there'll be, all reports on all 3 will be given at the same time. So I had told, I had given opinions, on various TV stations and radios that the earliest we'll finish will be October. That's next month. And true, yes, look at it. 1st of September, that's when the report on the first one has been submitted. So we're still left with 2. You see, so there's a surprise that it came earlier. But, like Chief Justice Torkonoo herself says, the law is the law. Nothing stops the committee in law from presenting a report on what they have finished. So if they finish, once they finish one, there's no need to let it stay on the shelves and gather dust. So I'm sure.
Yeah, but Counsel, looking at how sensitive the position of the Chief Justice is and how much public interest this particular issue had generated, would one petition be enough grounds to remove her? Wouldn't you have thought that maybe out of the 3, at least 2 should have enough grounds on which we can say, well, she has erred, and because of that we are taking her out? But after just one of the petitions had been thoroughly reviewed, the committee thought that it was okay to recommend her removal. You think it is grounds enough, or it carries that much weight?
Absolutely. Absolutely. One petition can remove a Chief Justice or, let's say, a Justice of the Superior Court for that matter. It all depends on what is in that one petition. Remember that this particular petition had more than 20 allegations, I think, if my memory serves me right. Yes, the count. Yes. So even in one petition, if it carries one allegation and that allegation is made out, it can lead to a dismissal. In the same way, if one petition carries 20, 30, 40 allegations, and let's say even 2 out of the 20 are made out, it can also result in a removal.
Are there any grounds now for Madam Torkonoo for what may be? Hello, Council, can you hear me? Hello, Council Pebu.
Yes, hello.
Yes.
Martin.
Good. I was asking that, is there any avenue for Madam Gertrude Torkornoo to challenge this decision, or it coming from the president after a thorough investigation like this brings finality to the case?
Yeah, so she can challenge it. So she can go to depending on what she's challenging. But most generally, because the committee is not a court, strictly speaking, she can go to the High Court. You remember the last court Madam Torkonoo went to in Ghana was the High Court. Yes, so this is a committee. If she's not happy with stuff that have gone in there, yes, she can do judicial review. Judicial review, because the Constitution doesn't mention appeal. You see that the two are different. Let's explain this very well, Martin. In law, when you want to say you are appealing, technical law, when you say you are appealing a decision, it is the law that has to give you the right of appeal. So we call it appeal is a creature of statute. You can only appeal if the law says you can appeal. But when you read Article 146, you don't see anywhere it is stated that when the person is not happy, the person can appeal. But as for going to the High Court, what we call judicial review, that one, you can go. You don't need it to have stated that if she's not happy with anything, she can go via judicial review. That one, you don't need it to be written. But when it comes to appeal, I'm appealing against a decision. There is a principle in law that before you can say you are filing an appeal, the law must expressly say you can file it. If the law doesn't say so, you cannot just go and file an appeal. The two are different. When you are doing judicial review, the way it is done is different from when you are doing appeal. Yes.
Okay. Counsel, thank you so much. And before you leave us, engage me, last question would be, we know that she wore two hats technically as Chief Justice and also a Supreme Court Justice. So does this dismissal kick her off both positions, or at least she now drops back to just the level of a Supreme Court judge?
It takes her off both positions. It takes her off both positions. So the thing is that Article 146 Clause 1, even is talking about a justice of a superior court. It's not talking even about the position of Chief Justice. Let's read it. It says that a justice of the superior court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior or incompetence or on ground of inability to perform the functions of his office, blah, blah, blah. So you see, it says justice of a superior court.
Right.
Chief Justice Torkonoo is a justice of a superior court. When we say superior court, we mean High Court, Court of Appeal, Supreme Court. And she's a justice of the Supreme Court, so she can be removed. So that's how, and once she's removed as a justice of a superior court, it affects her position too as Chief Justice.
Right. Okay.
Yeah.
Martin Pebu, thank you so much for your time this evening. Always a pleasure talking to you and bringing some perspectives to some of these national conversations. And clearly, many of you who have been listening and following this particular issue are also welcome to share your thoughts on our various social media pages. We're actually streaming on Facebook, so you can drop a comment there. Subsequently, we'll be reading it out to the rest of the world. Staying on the subject, though, we've also been joined by Alexander Kwejokom Aban, who is a private legal practitioner as well and a former member of parliament for Gomua West. Mr. Kwejokom, good evening and thank you for your time this evening.
Good evening, my brother.
right from the inception of this matter, when investigations commenced, the president or government, for that matter, stood the grounds that they are strictly following what the Constitution asks them to do. Now there is a final verdict on the subject. What are your initial thoughts on this? And has the presidency or government faltered in any way?
Thank you very much. You see, we have always educated on words like rule of law, rule of law, rule of law. Rule of law does not necessarily mean that you have a law to point to. Because the justification for all this has been that we are following what the Constitution says. But most of us who have done jurisprudence and have followed democracy know that it is not so much that you have a law to point to for you to say, oh, we are doing what has been actually given the law. But it has to do with how it touches the responsibilities of the people, right? How the people would say that in a chorus that this is good or this is bad. And so when you read all the theories, especially about the rule of law, I mean, pointing to a law is one, okay? And whether the law actually advances the aspirations of the people is another. Whether it is even-handedly used is another. So there are many strands that go into the rule of law. We always sometimes talk about Nkrumah. Whether good or bad, was backed by some law. PDA was an act of parliament. But would you say that because there was a law to point to what you did was right? Indeed. I am saying here and now, and I think I've said it on your network, that probably those who put together Article 146 of the Constitution, let's put it that way, and gave the provision that in the case of the Chief Justice, her removal should go through Council of State. Probably, if they are alive, they will be thinking through it. They never envisaged that the Council of State, which is the civil layer, would be so partisan that their role in this whole exercise meaningless. Because for me, if was brought out and anything to go by, all the allegations that were made, anything to go by, I still stand by what I said earlier, that it did not even meet the threshold of rule. But we must see this removal from the perspective of the historical things that they themselves had said, including the president.
Okay, I get the point you're making. Unfortunately, the line isn't too clear, so maybe you would want to reposition yourself for us so we can have the full import of your submission. But while at that, though, are you suggesting that due process was not entirely followed, or there are some questions that need further probing before coming to this final conclusion?
We do not know the piece of evidence that was before the committee.
Unfortunately, we seem to be having a challenge with the line of Alexander Kojukom Aban, a private legal practitioner. He's also a former member of parliament for Gomoa West. We'll try and re-establish that connection, and hopefully it's a better one from what we have had earlier. We have challenged hearing fully the submission he is making, but clearly the news that everyone is reacting to at the moment is that of the decision of President John Mahama to follow through with the recommendation of the Article 146 committee that was probing the Chief Justice Gertrude Torkornoo, who has been removed from office with immediate effect. You would recall that right from the onset, when the 3 petitions were presented to the president followed through what constitutionally he was mandated to do and forwarded the petition to the Council of State, and then subsequently the committee was set up to look into the merit or otherwise of whether or not the Chief Justice has fallen short of expectations of the holder of that office. And eventually the Chief Justice came out to say that if even the government or the president was going to undertake any decision, she also needed to be given the right of response. And the president actually gave her time to respond. So the 3 petitions presented to the president were also forwarded to the Chief Justice, of which she responded in quite a very worded statement. And based off on that, the committee was also giving her response and the petitions. She has been to court a number of times seeking different things. One of it was to get the court to suspend the committee that had been set up to look into the petitions presented to them by the president. Also, she elevated the case out of the Ghanaian jurisdiction to the ECOWAS court, where the case is also being heard, and we have not gotten to the end of that as well. And the last few weeks, you would recall that the Commonwealth lawyers also wrote a letter to government asking that she be reinstated as the Chief Justice, because the president, upon receipt of the 3 petitions, asked her to be on suspension while investigations were ongoing. So she has gone through thick and thin trying to justify why she believes the process in the first place to take her out of office was flawed when you look critically at the Constitution. But at the end of the day, the committee, the Article 146 committee set up by the president, after probing, investigating, and talking to people, and it's interesting, the issues that were captured in the final report that was submitted to the president, because we know that, for instance, 12 witnesses testified in support of the Chief Justice when this Article 146 committee started its hearings, and also 10,000 pages of documentary exhibits were received by the committee, which had to take time and go through all these evidence to ensure that their final outcome was watertight. Again, 4 lawyers represented the first petitioner and 4 lawyers represented the Chief Justice, and just because they wanted to give fair hearing to what the Chief Justice had to say regarding these petitions that were brought against her. The second and third petition hearings had been adjourned. So, like you heard Martin Kpebu say, of the 3 petitions that were brought against the Chief Justice, it was only one that the committee based its final recommendation on, and just that one was what they came out with their final report on, submitted to the president, and based off on that, the president has recommended or has actually gone through with a recommendation for her to be removed. So she actually now is clearly one that we can safely say is a former Chief Justice, and we are yet to find out what then even this means for the cases that she was trying to litigate in court. What happens to those cases? Are they on the face of it moot at the moment, or clearly they still have some nuances around it that the system need to allow for her hearing to be done? In the coming days, a lot of legal perspectives on this have come up, and we'll try and get you the best brains to also try and ascertain whether or not there is any merit to the accusations and allegations currently coming up. But we would update you subsequently when we do get further and better particulars regarding this. But at the end of the day, what we have on the papers right now from the office of the president is that Madam Gertrude Esaaba Torkonoo has been removed from office and no longer Ghana's Chief Justice. So there is an acting Chief Justice, and we would also then hope to hear what the President will do. Would he now be affirmed as the Chief Justice of the Republic, or there's a likelihood that someone else will now be nominated for that position? We'll definitely update you subsequently here on 3FM 92.7. And we have also a copy of the letter signed by Felix Kwachi Ofosu. It's on our website, 3news.com, or you can go to our social media handles and you will definitely hear all of that as well. Now, Felix Kwachi Ofosu, after the letter was released, which he had signed, also spoke briefly to us, trying to give further perspective as regards what the government had considered strongly before coming up with this final verdict. He spoke earlier to Alfred Okanse, who was also probing to find out what must have informed the final decision.
I believe so, except to say that the chairman of the committee in the presentation of the committee's report stated that there were two outstanding petitions that they had not looked into because they had received representations from the parties involved for an adjournment of hearing into those matters. But with respect to the Daniel Ofori petition, there was no such request, and therefore they proceeded to look into it. And it was on the basis of their work on that petition that they have recommended the removal of the Chief Justice, which the President has done, as communicated in the statement that I issued a while ago, to dictate to the committee how they should or when they should do their work. So it is entirely within the president of the committee to decide what to make of the outstanding two petitions. But the President has acted strictly in accordance with the constitutional stipulation that enjoins him to carry out the recommendations of the committee. That is what has happened today.
How do you respond to the likes of Joshua Zato on the other line, who says that all of this process...
The party that you would expect him to take a position similar to what his party has taken. If he doesn't furnish any basis for that position, except to make it, just like his party propagandists and members have done. But everybody who is fair-minded and has followed this process will be clear in their minds that the President has stuck strictly to constitutional provisions. As of the MPG, they can abrogate and reproduce that when they want. When they were in power, the same as the 146 was used to remove the then head of the Electoral Commission, Madame Sanatosa, and two other deputies. I didn't hear Dr. Gato offer a whimper on that occasion and express any belief of political motivation. Suddenly, political motivation has been invented by him to smear this process in order to achieve a certain political end. I don't think that is the kind of discourse or commentary we should be having on this particular matter. Let Dr. Zato and the rest of them in the MPP point to any specific infraction on the part of the President in respect of his handling of this matter. And you will find that, and indeed to date, nobody from the account has been able to point to any infraction, or no other person in any quarter within our society has been able to point to any infraction. That clears you. That shows you clearly that the Rama has acted above board. He has acted within the limits of the law, and that is what the law says should be done.
I see. Well, it says the President could be executed, and that...
How so?
That's
that all rest in the Constitution. Which part of the Constitution is that the President can decide not to forward it? The Constitution is clear that upon receipt of the petition, the President shall, in consultation with the Council of State, determine prima facie. That is the word of the Constitution. How then does Dr. Gato decide on his own that the Constitution should be disregarded because he believes that his party must rule as support behind the Chief Justice? I don't think that we can have a entertain that kind of logic.
Okay.
And that is Felix Kwachi Ofosu, who is the government spokesperson. He's the head of government communication and presidential spokesperson there in that interaction with Alfred Okanse. This is still 3FM 92.7. We are live from our studio here at Adesanwe Kanda in Accra. Well, so that's a big story.